some people call them dump truck lawyers, because they want to take as much money as they can from you and do as little work for your case as possible, because, hey, you're not really present in your case, so they can get away with it. They'd rather focus, 90% of their energies on a case where they're getting paid a lot more money, and they have very clear, specific evidence to work with in their case. This isn't always the case in rape allegations and sex crime allegations. There's usually no evidence unless a rape actually occurred. What we know traditionally to be, the alleyway jogger rape, right? Where someone attacks you out of the bushes, there's an actual crime scene, there's a knife in the bush, there's rope, there's torn clothes, there's blood, there's DNA, there's CCTV footage, there's witnesses, there's you've got physical evidence to work with in a real rape case. But when you're dealing with a case where you admit that you had sex with that woman that night, she says it was rape, you don't say it was rape, it was consensual, then the DNA doesn't matter, because you don't need to prove that you were there, because you're already admitting you were there. So technically, there's not really a crime scene. Technically, therefore, there's no evidence other than, her physical exam. And then it becomes subjective and speculative whether or not whatever blood or lacerations she might have gotten during the sexual encounter were as a result of forced penetration. But that's subjective. There's so many other reasons that could have happened. She could have been on her period. She could have been menstruating. Dude could have had his penis pierced and caused all sorts of bleeding. She could have been a virgin, and that causes a lot of bleeding. There could have been anal sex. That causes bleeding. There could have been sex toys involved. She could have done it to herself, specifically to pin it on you so that she can go off and claim compensation and get all kinds of money and, have an excuse and a cover up for her drug habit. Right? So defense lawyers don't really like those cases because they're impossible to defend against. They're really difficult to make you look innocent. It's So the best thing to expect is when you're accused and you're innocent of whatever the accusation is, you have to work with your lawyer. You have to direct your lawyer. You've got to do research. You have to research how the criminal justice system works, what the defense lawyer's legal ethics are that he or she is bound by. And same for the prosecution. You have to do that research. Unfortunately, you may not have the time for it. You're going to have to make time. You have to be part of your own defense strategy. You've got to provide the evidence. If there is any digital communications, you have to help piece something together that you might not be able to fully understand, how it can help you or how it can help the defense lawyer build a narrative, but you have to participate in that process so that together you and your lawyer can come to that narrative that makes more sense, so that your defense lawyer has a direction when he's defending you. Because if his only direction is to prove that she's full of shit, then that's not going to go anywhere. In Canada and in the United States and in the UK and in Australia and Ireland and Scotland and pretty much every Western country in the world right now, saying that the accuser is not credible or trying to prove that they're not credible is only viewed as a attack on her credibility, and is not reason enough for a jury to find you innocent, to find you not guilty, or for a judge to not judge against you. It's not enough reason anymore. You can't say she was hopped up on cocaine and, vodka or whatever. You can't say these things anymore. You can't say that, therefore, because then the courts just say, well, that just because she was drunk or high or stoned doesn't mean that she's automatically consenting. Well, you know that, right? That's not your point. Your point is that you guys were together, you were both drunk and high, you had sex, and then the next thing you know, you're being hauled off for a rape claim, and you know you didn't rape her. But you can't use that as a defense anymore. So really, with my research, the best way to win, if it does have to go to court, and even if it doesn't have to go to court, in a pretrial motion, you can collect enough evidence that contradicts her claims. Hey there, do you find this content valuable, informative, and thought-provoking? If you do, there are links in the description bar for multiple ways to support my work. Donations help to sustain the production of content that informs and inspires viewers like you. Support what you value by contributing one-time or monthly recurring. Buy merchandise to take a stand and start a new conversation. And last but not least, subscribe to this channel, like, comment, and share to help this channel grow. So you can't necessarily collect evidence that shows she's not credible in terms of alcoholic tendencies, drug addiction, mental health. You can't use those against them anymore to show that her claim is not reliable because of those states. What you need to do, the thing that I find most common, and again, I'm not saying these things as a lawyer, but just from my own research of having read overturned convictions and appeals that weren't successful, is the real clincher is you have to specifically catch them in significant lies or contradictions. For example, let's say the Jian Ghomeshi case. The Jian Ghomeshi case was, I believe, one of the complainants had specifically hinged her claim on a yellow Volkswagen that she was sitting in with Jian when he allegedly attacked her. And she gave a specific date, or a very specific date range of when this attack happened. So this was all on record. Well, Jian Ghomeshi and his defense attorney were able to find a record that proved he did not own the yellow Volkswagen until far later after her claim. So that was what did it for that particular witness in the judge's eyes. That might not seem significant to you, but it's in the legal world. A contradiction like that, a misremembering of something like that, is very significant. So these are the little things you need to pick out. So the very first thing you need to get when you have a criminal accusation against you is the entire transcript of the accuser's interview with the police officer. And that can be difficult to get as well, but you have to have it. You have the right to it. You have to demand it from your defense attorney. Your defense attorney might give you excuses and reasons. The Crown doesn't want you to look at this. The prosecution doesn't want you to have it. Well, then I can sit in your office and read it and take pictures of it with my cell phone, right? Or, you have to have access to their claim. This is how you can build your defense. If you have a lawyer, and I've heard this happen, if you have a lawyer that tells you, I can't give you the transcript of your accuser's statement, how the hell are you supposed to build a defense? That's not right. So you have to argue and fight to get that, or somehow get in the office with the lawyer and read the transcript and take pictures of it. You are allowed to do that. Nobody's going to come in and arrest you. And if your lawyer is trying to prevent you from having access to that claim, you need to find a new lawyer, because that lawyer is not helping you. He's not helping you build and participate in your own defense. You need another lawyer. Now, some lawyer might have another viewpoint on that, and they might want to comment on that. That's open for discussion, I suppose. So it does happen. Believe it or not. Your own lawyer, your own defense lawyer can work against you. So when you get to court, one of your pretrial hearings will be, admission of evidence. Whether it's yours, well, most likely it would be yours. But if there's bad character evidence against you, you can work with your lawyer to have that omitted. You can work with your lawyer, have a trial or a hearing to have the judge throw the bad character evidence out against you because it has nothing to do with your case. And this is very important because the same standard applies, but by default when it comes to the accuser. Any evidence related to the accuser that you want to admit can only be relevant to the alleged assault. But when it comes to you and the defendant, anything goes, and it's not fair. But you can stop that. You can direct your attorney, your defense attorney, and tell them, okay, so they're going to try and use this against me, this stuff that they talked about in the police statement. So I want to get my entire police statement, or maybe even part of it, omitted from the record. I do not want it on the record. Because once it goes on record, then it's always open for it to be used against you. And also, if you don't testify, if you choose not to testify at court, then that police statement will not be admitted at all. Or if you don't make a police statement and you say nothing on the record, then you don't have that there's no at trial they can't compare statements that you made at the police statement to statements that you're making at trial. That's something that prosecutors love to do. They love to say, oh, well, at the police station you said red, but today you're saying mauve. Well, I think you're full of shit. Prosecutors love to do that. And you know what? Some judges will agree. They'll say, yeah, you don't seem too clear on whether it was red or mauve, so I don't find any of your evidence credible. So I am just going to reject it all, and therefore I believe her story. So you're guilty. That's how simple it is to be found guilty. So the bottom line here is, if there's a false criminal accusation made against you, you have to take it very seriously. Even if it sounds like the most ridiculous thing you've ever heard, there's no way it's going to go any further in court. There's no way anybody's going to believe her. It's ridiculous. You have to take it seriously. This suddenly is going to be your only mission, your most important goal in life as soon as this happens. You have to take it seriously. You've got to get all your witnesses together. You have to ask them if they're willing to give affidavits for you, and if they're willing to testify for them in court. Basically, your witnesses can make an affidavit or provide an affidavit in your favor, but that affidavit means nothing unless they actually testify to it in person in court. You have to know that as well. An affidavit is not enough. Another aspect that's really important when it comes to false accusations, when the context is not in a relationship breakdown, or a workplace context, or a school or university context. The other categories where you've never met the person, or you only met them on that day where they claimed you did something to them when you only bumped into them in a convenience store or something like that. Or an acquaintance context, or in a familial context, where a claim comes out of the blue. These out of the blue complaints, these ones have the hallmark of a therapist involvement or a third party involvement, brainwashing type of motivator that creates this accusation. These are very common, way more common than we would like to believe, but they do happen. They have been happening for decades, and they still happen. And I think they're happening more and more in our courts. And this book that I suggested, it touches on it a little bit. There is actually a section, where is it? To catch a sex offender, police, trolls, and personal injury solicitors. Beliefs about memory, childhood abuse, and hypnosis among clinicians, legal professions, and the general public. Okay? This stuff is still very relevant to today, and very, very important that you be aware of them, because that could be the reason behind a false accusation in these cases. Let me give you an example of how destructive these therapy-induced false accusations are. Somebody just brought to light a situation where there's a couple that they knew for many, many years. They had been a couple for many years. They ran a business together and everything, very successful, very tight, one of those couples where you would never imagine ever breaking up. Well, apparently the husband came home one day and told his wife that he had uncovered new memories, or uncovered repressed memories of childhood sexual abuse. Don't know the details of who it was, if it was his babysitter or neighbor or an uncle or a parent. Don't know that detail. But that doesn't matter. Well, it does, because whoever the target is, their life is about to be destroyed as a result of this. But that new revelation that came out during therapy sessions then proceeded to demolish his relationship with his wife. His wife apparently is like something maybe like me, common sense, like, well, I need to see it to believe it kind of thing, or where the hell did this shit just come out of the blue from? Are you sure that's true? Are you sure that's real? Apparently the wife is that kind of a person. So I don't know the details. I'm still hoping to find out more, because this is very interesting to me. But yeah, and end result is the couple's relationship is over, completely severed. Dude's off in his own little victimhood corner, curled up in the fetal position, while she's moving on with her life and just doesn't want anything to do with it. It's really sad. It's really unfortunate, but these things are still happening, and I can't imagine who the target of that accusation. I can't imagine what shambles their life must be in right now. Again, in this book, there's a section there that talks about personal injury lawyers. That's often the first avenue that these people will take is, all right, I want restitution. I'm going to sue this person for everything they have because of what they did to me. But in reality, that person did nothing to them. What happened was the therapist just implanted some bullshit delusion into their head, and that is what's causing them trauma. Suddenly, the therapist has created all of this upheaval in their life, in their spouse's life, in their family's life, and the life of the person that they're accusing. But yet they're looking to sue the person that they're accusing for all that they have. And one of the first questions the personal injury lawyer will ask is, how much are they worth? What assets do they have? What do you know? Is it worth it to go after this person? And you might find out it's not. This person might not have any assets. So what's the next step? Well, criminal charge. Then that way you get more money from compensation, the Criminal Injuries Compensation Board, if you can get a conviction. Now we all know, or I know, you don't need a conviction in order to successfully apply for criminal injuries compensation. You don't need a conviction in order to get money. But you do need a conviction if you want more money. Money that you were hoping to get in a civil suit, but then later found out, he's worth nothing. I'm not going to get any of those assets. So I can make the claim through the criminal process. That's a real motivator for these people. A real motivator. I don't know why people deny that, but money is always a motivator. So if you're being falsely accused and you're motivated by money and you'd like to keep your money, or if you would like to consider the best investment for your money, at that time, being falsely accused, the best investment is the best lawyer and working with that lawyer to make sure he's spending your money properly and in your favor. Okay?